Welcome back, everybody, to our studies in business law and practice for the SQE specification. In this video specifically, we are going to be finally looking at the end of this first part of the specification, where we have been spending most of our time just delineating the different types of business and organizational structures. And we're going to finish in this video by looking at the idea of the LLP, the limited liability partnership. So we'll talk about the limited liability partnership in this video in a sort of brief generality and an overview, because essentially this first part of the specification, as far as I'm concerned, is just an overview of all the things that we are going to be spending a lot of time examining throughout the various different lessons on business law and practice. So we're going to talk about partnerships and LLPs in far more detail in its own separate chapter on the specification, as well as looking at unlisted and public companies as well, which is the majority of this series of videos on the subject of business law and practice. And then we're going to finalize this whole conversation by talking about various different tax implications associated with this topic. So, as a basic introduction then, the limited liability partnership is a very interesting type of structure. It's a very interesting type of business structure, because we know already what the idea of the limited liability is, the idea of incorporation, the idea of creating an entity in law that has separate legal personhood. And we know already what the idea of the partnership is, the idea of two or more individuals coming together and doing business with a common purpose, with a common vision for business growth. Now, the idea of a limited liability partnership then merges these two ideas together. It blends the concept of the limited liability in the process of incorporation with the concepts of the partnership in the unincorporated form. So we've noted, for example, that the idea of the partnership has historically been an unincorporated type of business, just like that of the sole trader. It's basically like a sole trader, but with an extra person, or at least more than one extra people, if necessary, if need be. And the limited liability, of course, goes through this process of incorporation and involves the establishment of the company. Now, the regulation of the limited liability partnership is regulated by, as the name suggests, the Limited Liability Partnerships Act, which is established in 2000. So the Limited Liability Partnership Act defines this form of legal entity of a limited liability partnership by beginning and saying there shall be a new form of legal entity, and this legal entity will be known as the Limited Liability Partnership. A limited liability partnership is a body corporate, i.e., with legal personality, separate legal personality as established from its members. So it goes through the process of incorporation like a company, for example. It is a body corporate which is formed by being incorporated under this act, going through the process of incorporation, and in the following provisions of this act, and in any other enactment otherwise established, references to limited liability partnership are such a body corporate. So essentially just a bit of legal mumbo jumbo to explain to you what a limited liability partnership essentially is. Now, a limited liability partnership also has unlimited capacity. In addition, the members of a limited liability partnership have such liability to contribute to its assets in the event of it being wound up, as is provided by virtue of its acts. So, essentially, the members who create a limited liability partnership, at least two or more people, will have such limited liability when it comes to the obligation that they might have to contribute assets to the creditors of this company in the event of that company being wound up. So we've spoken about this briefly, and we will obviously get into this in great length when we talk about insolvency law. But fundamentally, the idea here is that the idea of insolvency is that you cannot pay your debts as they fall due. You've got a load of creditors. You have to pay those creditors. You don't have any money to pay them. You become insolvent. One of the ways in which the law deals with insolvency is to wind up the company, to essentially liquidate the company, go through a process of insolvent liquidation, which involves essentially breaking the company up and using the assets that the company owns to pay off creditors. And there's lots of law associated with the idea of paying creditors and the order in which creditors are able to be paid and all this kind of stuff. And a limited liability, of course, means that a person who founded that company or is in control of that company, that their personal assets aren't necessarily on the line when it comes to the process of winding up that corporation. And the same principle will apply here. Accordingly, except as so far as otherwise provided by this Act or any other enactment, the law related to partnerships does not apply to the limited liability partnership. So this is one of the things that needs to be noted as well. There is a Partnerships Act from the 1800s, the 1890, I believe it was, that we spoke about and we referenced when we looked at the law of partnerships in an earlier lesson. This is a different type of thing. So where there are relationships between those two concepts, where the concept of the partnership and the limited liability partnership do have similar characteristics, it will be specified in the Limited Liability Partnerships Act from 2000. If it is not specified, then it is otherwise separate thing. It does not apply. So the law related to partnerships that is not otherwise provided by this Act or any other enactment, that law does not apply to this type of business legal entity. The schedule, which makes the provision about the names and registered office of limited liability partnerships, has effect. So just a little extra bit at the end there. The formation of an LLP then is done through the filing of corporate documents with the registrar of companies at Companies House, just like the establishment of a company through Companies House, an ordinary private corporation, an ordinary limited liability, for example. In addition to this, LLPs are formed by two or more members which are carrying on lawful business with a common view of profit. So this definition of a limited liability partnership, of the partnership part of that, is very similar to the 1890s Partnership Act. If we remember back to that lesson, Section 1 of that legislation says that a partnership is essentially where two or more people come together carrying on lawful business with a common view of profit. So the definition of the partnership in limited liability partnership is very similar to the unincorporated type of partnership. The difference is, of course, that it is a limited liability partnership. It's slightly different. We'll get to this in more detail in future lessons because, as I've mentioned, the specification basically at the start gives you an overview of all of these different concepts. It basically provides the educators give you some insight into what each of these things are. And then in the specification later on, we tackle the issue of partnerships in far more detail. So we'll get to that in a future lesson.